The number one question I get asked by employees looking to start a new job is, if I signed a non-compete agreement with my previous employer, is it enforceable? We at Denton Peterson are here to answer that question. So let's get right to it. First, it should be noted that a non-compete agreement is different than a non-solicitation agreement or a non-disclosure agreement. Non-compete agreements focus specifically on your ability to work, not on your targeting clients or your divulging company information. Second, it should be known that courts generally disfavor non-compete agreements. So, for a non-compete agreement to be enforceable, it needs three things. 1. A reasonable limitation on the type of work an employee can perform. 2. A reasonable geographic scope. And 3. A reasonable time duration. What is reasonable then? Let's look at the case of John, who is an assistant manager for XYZ company, which manufactures horse saddles to be sold online. Let's walk through the steps. First, what would be a reasonable limitation on the type of work that John can perform? To be enforceable, XYZ company cannot simply restrict John from doing anything that the business does. The restriction must fit what John is specifically doing for the business. If John only manages the customer service department, then XYZ company cannot restrict John from finding a job with a competing company in their IT department. 2. What would be a reasonable geographic scope? To be enforceable, XYZ company must figure out what its client base is. If XYZ company sells items online, then it technically could request a worldwide non-compete for John. If, however, XYZ company sells only in one store in Phoenix, Arizona, then it will be tough to have a non-compete larger than that area. Third, what would be a reasonable time duration? To be enforceable, XYZ company must determine how long it would take to train the new employee to have the necessary skills of the job and develop the relationships with the company's personnel and clients that John had. Understandably, for lower level employees, this time restriction cannot be as long as it is for management or executive level employees. With this in mind, you can see that the specific facts of your situation play a significant role in whether or not your non-compete is enforceable. I know that the question of whether non-compete is enforceable or not can keep individuals up at night. That is why at Denton Peterson, we have a 48-hour weekday response policy. After you choose Denton Peterson to represent you by signing and complying with the terms of the representation letter, we will meet with you and figure out whether your non-compete is likely to be enforceable or not within 48 weekday hours. At Denton Peterson PC, we have reviewed Arizona case law and court opinions on the enforceability of non-compete agreements and have in-depth personal experience in this area. This makes it so that we can confidently evaluate your case. In addition to the 48-hour weekday response policy, I personally charge a flat fee for employee non-compete issues. By doing so, I hope to accomplish two things for you. The first thing is to give you certainty regarding your legal costs. The second thing is to give you trust in the attorney-client relationship. As an employee, when you have a question about non-compete agreements, call Denton Peterson PC at the number 480-325-9936. Let me help you take the uncertainty out of your life.